Thank you. May it please the court, I am Alan Medvick. I represent the appellant, Michael Jones, in this matter. We've raised issues on appeal concerning insufficiency of the evidence and verdict contrary to material weight of the evidence. This is a case that involves a home invasion regarding a methamphetamine lab. My client, Michael Jones, was found guilty of multiple counts, including manufacturing, possession of chemicals, and endangering children, all of which relate to a methamphetamine lab that was found inside the home. My client, Michael Jones, was not a resident of that home. He was essentially a homeless person, relative of the wife of the home of the co-defendant, Mr. Keith, and I think the evidence, including testimony of Mr. Keith, verifies that he was not a resident of the home. He was not found in possession of any chemicals. He simply was in the house. I think that there is the basis for the finding by the jury was an interview with the police officer, and the police officer's interpretation of that interview, which involved Mr. Jones clearly had knowledge of how to make methamphetamine, but whether that knowledge could be imputed to mean that he was making meth on the evening of the 29th of September.
Now, when did he buy the Sudafed in relation to when the actual meth was cooking?
I believe there was a purchase of Sudafed on the 28th of September from Walmart.
And they were cooking the next day.
I also believe that the officer himself stated that he could not specify that was, there was no way to know that was the same Sudafed. I think that is probably the strongest point of evidence. I'll concede that point, but again, I don't think that there's any way to verify that Sudafed, that purchase, again, regarding that, in particular, I think does not speak to, at worst, that speaks to a finding of possession of chemicals. I think it would specifically not support the finding of a manufacturing charge, which is significant in this case because the manufacturing charge resulted in mandatory time for my client.
So it would be not direct evidence, but certainly circumstantial evidence.
I think it could be circumstantial evidence, but as regarding that, I think specifically only to the possession of chemicals. I think that's where that line is between those two charges. That
you don't think that the purchase of the Sudafed has any bearing at all on the manufacturing?
I think that there's no evidence that my client at the time was manufacturing. And I think that the Sudafed, my client was asleep in a bed. I think that the Sudafed at worst was purchased for that purpose, but I don't know that it would support a manufacturing charge at this point.
So you're saying the detective just misunderstood Mr. Jones?
I think that there's a stretch as to what he said in the interview regarding how he interpreted that, to imply knowledge as to imply, especially with Mr. Keith saying expressly that he was the sole cook at that time on that evening.
Go ahead, please.
Your client said, did he take the witness stand?
He did not.
Okay. And so
the testimony, all of the testimony I think is regarding my client is through the recorded interview and the detective's interpretation and statements regarding.
In the recorded interview, did your client tell the detective that he was asleep at the time that the police arrived?
I believe he was found asleep, yeah.
He was found in the bed, but I thought that the state's brief suggested that there are different inferences that could be made from the fact that he was in the bed. And one of those inferences is that he was hiding there, and not that he was asleep. So
But
I wondered what that
one of
is.
but I think that regarding whether he was hiding, I think he was not under the bed, he was on top of the bed. The person who was in the bed with him was asleep. I don't think there's any dispute in fact there.
Mhm.
If my client had come bursting in at the last minute, I believe, as with the police when they came in, I think the child would have woken up.
Well, she was 15,
I
right?
think she was 15.
Does anybody feel a little uncomfortable that he's alleging he's sleeping in the bed with the 15-year-old? Or is that just me?
Maybe.
I mean, that's an awful.
Fortunately, that's
I
not.
would sleep with a 15-year-old.
Fortunately, that's not the issue.
I know, but I'm just saying.
Um,
And couldn't the jury look at that and say, gee?
And maybe, just as I hate to concede anything.
No, that's,
but-
I'm just thinking because nobody really mentioned that in either brief, and I'm like, wow, that's kind of
And-
disconcerting to me.
But I don't think there's, and yes, I think that's unusual, but is it, I'm not sure that rises to, there's no allegation of, it seems everyone was clothed. I don't think there's any allegation on any party that there was anything untoward there.
All I guess I was intimating,
Yes,
intimating was maybe it goes to Judge Moore's point that he was hiding there because nobody charged him with anything in regard
And I
to
understand.
Pretending to be asleep.
pretending to be asleep, right?
Okay.
But at any rate,
But at any rate,
yes, go ahead, I'm sorry.
no, unfortunately, when heaven doesn't show up, I'm pushing against a rope here a little bit. And I think my facts, the arguments are pretty clear here. I think it's understood what I'm trying to say here, that I think the case law is pretty clear that mere presence is not possession. And my client didn't have a property interest in the home. He didn't have any manufacturing materials on his person. I think we're making a long series of presumptive decisions to get where we get.
Go ahead.
What are we to make of the recorded jail call from the uncle discussing your client's involvement, even though the uncle then apparently testified for the defense that your client was not involved?
I will leave that to your interpretation.
All right.
If there are no further questions, I will.
And that's what I was going to say with Judge Moore's point is you do have not the homeowner, but the legal resident come in and testify that he wasn't involved.
Yes.
Well, thank you so much for your presentation to the court. I'm sorry.
Thank you very much for your time.
Oh, yeah, thank you. We will take the matter under advisement and issue a written opinion, and we'll send it to both sides and also post it on our website.
Thank you.
Thank you. Have a good day.